Good morning, everyone. I'm Ann Koontz. I'm here with Marina Parkin, my partner in crime and partner in tax and partner in shenanigans. She's the she to my nanigans. Today is Tuesday, November 3rd. We are prepared for the election. You have a choice today. You can choose partnership or S corporations.
Yeah, let's vote on that.
Exercise this tax right to choose how you want your entity to pay, because you're going to pay. That part is not a choice. So we wanted to get started and let you know that, as always, our webinars are recorded. They'll be distributed on YouTube and Facebook and on our websites, Koontzassociates.com and KoontzParkin.com. As always, we welcome your questions in the Q&A box at the bottom. We'll address those as we go. And if you have topics that you'd like to hear about, then you can just let us know and we'll be happy to cover them. So without further ado, let's talk about how do we even know what we want to be? And first thing we need to talk about before we even get to that election is what type of entity you want to be. So lots of times people come over to have a consultation with me after they've met with Marina and they're like, okay, give me an S Corp. And I'm like, well, that's not really a thing to give you. When we talk about choice of entity and how we're going to be established, first we have to set up our company from a state law standpoint. So that means you've got to go to Florida, sunbiz.org, get a company. You have to have articles of organization, if it's an LLC, and that's basically the birth certificate to the company. Once we have that, we get a tax ID number. At that point, that's like the dinner menu. What would you like to be? Would you like to be an LLC? Would you like to be a corporation? Would you like to be a partnership? What do you want to be for state entity law purposes? Then we have to take that entity and go to the dessert menu and pick how you'd like it to be taxed. The thing that I think often confuses folks is they'll say, well, I thought you just told me to be an LLC and now you're telling me to be an S corporation. So where do I find that on Sunbiz? Well, an S corporation is not a thing to be. It's a method of taxation. So it's an election that we make to say, hey, IRS, you don't have a tax form, for example, for LLC. So I have to tell the IRS how I want them to tax us. And with that, we make our election. So once they pick their entity, what's the first line of questioning, Marina, that you have when it's time to start filtering through? And I guess maybe we talk about the choices as we go along. But what's the first line of question you have?
It is a perfect actually start, because formation is always one of the first things that people ask. And one of the first questions that people ask me when I tell them that it's time for them to be an entity is, well, what's easier to form? Is it easier to be an S corporation or is it easier to be a partnership? And this is where I'm glad that you mentioned, Joanne, that when you form an entity on Sunbiz in Florida and the equivalent in a different state, is that you have to form an entity to begin with. Now, let me also say, and when you read anything about partnerships, is that partnership can also be an assumed entity. So if you and another person are operating a business together, even without having any legal formation, and you are holding yourself out to be a partnership, you can actually technically be called a partnership. So I think you have to be really careful. Joanne, have you come across any cases there when that has come up, I guess, on the legal side?
When people are holding themselves out to be in business, absolutely. We see it most commonly for our realtor friends who operate on a team. In Florida, we have a concept called unincorporated business association. What that means is you've held yourself out in the public. You've put both of our smiling faces on maybe some marketing materials or on some promotional materials. If you've told the public you're in business together, we see it with the realtors like Team Koontz, and there's a picture of Marina and I. Even if we don't bother to form an LLC or a partnership, the state is going to say, well, you told the public you were in business, so we're gonna act like you were in business. And the main reason that that's of interest, my favorite people, Morgan and Morgan for the other people, they're going to make this argument to say, well, you were an unincorporated business association, and therefore, if Joanne has liability, we want to go after Marina because They were in business together. Well, because there's no business entity legally to protect you or to provide any liability protection, guess what? Now, my mistake, they can come after Marina's rental properties, her unprotected assets, things that are not, protected from creditors, that it's my issue and they can come after my partner. So at least if we've got the benefit of the actual entity there, if something happens, we've got the insulation of the individual owners from the liability. And more importantly, you have an ability to get a really inexpensive liability insurance policy that you can't get if there's not a company. So for a couple $100 a year, I could get $1 million policy that's going to cover if something happens. And it's having the entity is inexpensive insurance, and then having the actual insurance is inexpensive, but you can't do it without the entity.
Absolutely, absolutely. Now, is it also true, Joanne, that you can actually form a partnership as an actual partnership without forming an LLC? So you can intentionally form a limited part, an LP, or any other form of partnership without actually forming an LLC. So it's my understanding.
Go ahead, sorry.
It's my understanding that if you start with the LLC, you have a lot more flexibility later down the road of what it is that you want to be. Because if you decide to hold yourself out then as partnership, you already have the structure. But that also gives you the ability to do an S Corp election or any other election if you formed as an LLC. If you form yourself as a partnership to begin with, like an LP or any other type, or general partnership, you don't have an ability from there to do an S Corp election. So I think an LLC is always our first preferred method to form an entity, and then we decide for tax purposes where we want to take it. Would you agree with that? So LP or GP is not really
where we typically see partnerships, to be honest with you, are in real estate development agreements. So if we've got developers that are coming together to maybe build a neighborhood, that's where we see that. A general partnership a partnership in general requires one partner to have unlimited liability for the acts of the company. So the general partner is the guy that takes the fall. And in a limited partnership, there still has to be one general partner. So that's the downfall. Typically in a corporate structure like that, the general partner would be another company, maybe an LLC, so that they can get an individual human being out of that liability. But they're looking for that flexibility and the ability to get people in and out. That's why they use those partnership vehicles. You'll also see frequently, if you have investments into real estate investment trusts or REITs, those have a tendency to be partnerships as well. And there's a variety of reasons for that are beyond the scope of today's discussion, but you do see them in those circumstances. But that's the big difference between the LLC and any type of partnership, general partnership or limited partnership, is that there has to be some partner that has personal liability for the acts of the company, whereas in the LLC, all of the owners have insulation of liability.
Absolutely. And LLCs, I think a lot of people are still a little bit confused on the LLC concept and what is the difference. And I think really it's because LLC laws are probably the newest as opposed to all the other corporate laws. So now that there's an LLC opportunity in all the states, there is really no reason to start with anything other than the LLC and then go from there. But people who have had businesses for a long time and opening new businesses, I think they're still used to that old school. If I want a corporation, it has to be an Inc. If I want a partnership, I have to start it out to be a general partnership or whatnot. So it's definitely been a lot of educational time spent with clients to really encourage them to, when you do a formation, let's form an LLC, it gives us our legal protection. And then from there, we have the flexibility to decide, as you said, we're now into the dinner menu, what is it that we want to be for tax? And so that kind of segues me into the next common question that we ask is, well, what's the flexibility on ownership? So who can be the owner in the entity? And a lot of times that really pushes us into one or the other. So an S corporation has quite a limited type of owners. You can be an individual or you can be an S corporation, but it's very clear that an S corporation can only own another S corporation 100%. And that only happens in a, limited type of circumstance if you're trying to create a certain type of corporate structure. Generally speaking, though, it's going to be individuals or certain types of trusts that can be owners of an S corporation. You're also limited to these individuals being U.S. Tax residents. So if you have foreign folks that are investing, starting a business here, or any investing in a business, they cannot be owners of an S corporation. That is very, very clear. And so you've got another limitation is you can have only 100 shareholders in an S corporation. Now, typically for a small business, 100 shareholders is not really an issue, but when you're talking about having a bigger business, that becomes a restriction. So basically, if you have an entity that wants to invest in another entity, and that entity is a partnership can be a partner in another partnership, but it cannot be an owner of an S corp. So if you're trying to create multiple entity structure for, again, liability protection, or because it makes sense in whatever it is you're doing with your types of businesses and who are going to be the owners or whatnot, you definitely need to consider that an S corp is going to be very limited. So there's more flexibility with the partnership as to who can be the owners. A lot of times too, when we're talking about the foreign owners, it's really the ability to get that capital. So first of all, yes, you've got the foreigners that are coming in here trying to start a business. They are limited to, either be partners in a partnership or have a traditional corporation. But also, if you're a business that's trying to raise some money and trying to get investors, foreign folk that are even living overseas that don't have any other business interests, they can be partners in a partnership, but they cannot be shareholders of an S corp. So where do we typically then see an S corp in terms of the ownership is your typical small business owners that is running and regular active business in US, and that is, I would say most of those businesses are really 95% of them are S corporations. Any other restrictions on your end that you see when people come in and trying to form an entity? Any other kind of, when it comes to owners or any other restrictions that you've come across?
Just, the foreign people is a big one, particularly when people are maybe looking to bring other owners in over time, not necessarily to do a capital raise, like they're going to be doing venture capital or something, but they get a small group of people and they say, look, my friends might be interested, and people don't think of Canadians as foreigners. And so then that's usually where we run into a problem. I'm like, well, wait a minute, the names are similar to ours and the vocabulary is similar, so it's a little bit more difficult to identify, and it's not like people run around and talk about those things. So you want to be partners with Marina and you don't realize she's Canadian, and then all of a sudden we've got a problem. So sometimes people are a little further down the road on those negotiations and discussions when I have to bring that up, and they're like, ooh, I never thought to ask that. Like, so that's really, that's the big one that kind of think gets people by surprise, because it, very seldom are we dealing with people that are at 100 shareholders, although we have that conversation because we do have people who are saying, look, I want to start small and then I want to, I really want to blow this thing out. So if they're anticipating capital calls in the future, private placement memoranda, or other financing strategies for the future, then we may say, you know what, let's just take a different approach from here on out and not even go down the S Corp path.
And I also want to mention, as we're talking about the non-residents, that we are talking about residents for tax. These individuals don't necessarily need to be citizens of US. You can be a tax resident if you meet certain requirements, like you're here over 180 days, and there's also treaties between US and different countries. So sometimes folks come here with the intention of staying, but they don't have citizenship. They're on the visa and they're trying to apply for a green card, but in the meantime they may be on a business visa or work visa. And that's oftentimes a conversation we will have with these folks, including their immigration attorney, because if these people's intention is to stay in US and they've moved their entire family, they bought a business, they're here over 180 days, even though they're not citizens and not even green card holders, they meet the requirements to be considered US tax residents, and technically they can have an S corporation. And we work with quite a few folks that are on that E2 visa, that are running a business and trying to stay in US, and they definitely they're able to enjoy the benefits of an S corporation. So that is it certainly gets quite interesting, but we've seen it go the other way. We've seen people move back home, and we have to have that conversation, because if you become a non-resident, then we definitely need to notify IRS and get that S corporation election revoked, so you can get back into the partnership or maybe a different type of structure that fits you. So it can get quite interesting. So please don't try to do that yourself.
Speaking of that change too, that's another thing that comes up for people is I don't think they appreciate that you got to pick a horse and ride. Like, it's not S Corp this year and not next year, and then you you have a choice in the beginning if you're still in ramp up before your income level warrants a separate return if you are a single member, but you definitely can't be going back and forth once you kill that S corporation election or violate it by having a foreign partner or violating any of the other rules, then you're done. So
yeah.
Be careful.
So then the next thing too, and in terms of the flexibility, is the ownership percentage. And that always gets very, very interesting when we talk to people about, well, what's my percentage of ownership of this entity? So when you are an S corporation for tax purposes, an S corporation is considered a corporation then for tax with one class of stock. And that means that whatever ownership percentage you have, if it's not 100%, let's say you have another shareholder with you, let's say it's 70-30, you are 70-30 in everything, because that one class of stock, so you've got the voting rights, 70-30, you get to distribute your income, 70-30, you get to be subject to tax on the income, 70-30 split. And that is really, really very important, because a lot of times when you have multiple people forming an entity together, and they say, well, this guy brings the capital, and then I'm bringing, the know-how, and I'm bringing sweat equity, and I'm bringing a piece of land, then what is our percentage ownership? And this is where the partnership gives us the flexibility that the S corporation doesn't have. In the partnership, you have the ability to have a different percentage for splitting income, loss, and capital. So you can be 50-50 capital partners, but you can split your income and loss 70-30, which really, and the reason why you would do that is, again, is to sort of recognize how much of the initial capital or who's contributing what, so that when you start taking that back, you've got that percentage. And maybe somebody is going to be more involved in the day-to-day management, and that's where you would maybe give them a higher percentage on the profit split. Whatever the reasons are, you definitely have that flexibility, which is fantastic. Let me also say, though, that you can only get that if you've got an operating agreement that actually outlines these things. So if you form an entity, you form an LLC, and it is a partnership for tax, if you do not have an operating agreement, you are defaulted to equal split on everything among the members of the LLC. So if it's 3 of you, it's a third, and third. You're considered capital partners and income partners, a third. So the operating agreement is where you really get to decide on what's the capital ownership percentage, and then what is the income split, who contributes how much to the partnership, because that also helps you determine then who can take out their capital contribution and how that gets done. So this can get really, really technical. And I think that it seems to me like every single webinar we have where we say the word operating agreement, it just becomes this big thing, but you really have to have one in order to operate really anything, S Corp included, but in the partnership, it's key. And I think where I almost feel like there's a little bit of a disconnect because, again, people feel like if they form an LLC and it sort of defaults into being a partnership because you've got more than one individual and now it's a partnership, that it's easier. I already have the entity formed. It's already a partnership. And in fact, when you go to apply for the EIN number with IRS, once you form it, if you just have an LLC, IRS says, great, it's going to be a partnership because it's more than one member. And people say, great, I'm done. And then comes the tax return preparation. And at the tax return preparation, all of a sudden turns out that, you know, I had agreed with my partner that when we sell a piece of land, we get to split the capital gain, but the operating costs, because I'm putting in the money, all the operating loss all goes to me. Where do we have that? And then we have multiple variations of tax return. Who knows what gets ultimately filed or what copies get distributed. This is why I cannot stress enough on the operating agreement that actually specifies what we should be doing for tax purposes. So you got to do that to enjoy the flexibility. Please stop me here.
I just want to add, you said, when you said multiple versions of the tax return, that also leads to, you don't know what might get audited because now we're redoing that work and we're moving from one type of return to the other. And all of that would have been alleviated had it just been discussed on the operating agreement. So,
yeah.
And we can help you, if you plan for this, then you can negotiate the buy-in of people differently once you understand the rules. But oftentimes what happens is people sit down and ask us to prepare the operating agreement and paper the memorandum of agreement and say, okay, well, here's what we decided. And I'm like, well, you filed an S Corp election, you can't do that. Now they're like, well, what do I do? You go back and change the deal with the people that you made the deal with, or do you give up the S Corp treatment? Like, it's just not a good, it's a lot of wasted energy and effort on behalf of those involved in the organization. And it just doesn't get everything started out as efficiently as it possibly could from a tax perspective or from a financial perspective, because if those issues had been addressed earlier, you would have, we're not redoing the operating agreement. So that's definitely something to keep in mind before you even get started. Go ahead.
Also, when you are under audit, we did have a client who got audited last year. It was a partnership, and the first thing they asked for was a copy of the executed operating agreement. And there was an operating agreement in place, which was never signed by all of the partners. That's something that is key because, I mean, you can paper anything, and if it's not executed and signed, it's really, IRS can take any position. They can say, well, your intent was to do it, so fine, we'll do it, but they don't have to. If it's not, so let's say if you don't have it split up because you've got 70% of the profit and you've got 30, if you don't have that executed in an operating agreement, IRS can say, well, no, it should be 50-50 because that's what it defaults into being. So you really are taking a chance to do whatever you want if you don't have it properly documented and executed, if anybody picks up your return. And
if tax doesn't scare you, legal liability should. When we have that operating agreement in place, that's really the Bible to your protection. It's not mandatory in Florida to have an operating agreement for an LLC, but it is certainly an absolute best practice. We do have a question. Someone says, if I'm the founder and sole owner of an LLC taxed as an S Corp and someone wants to become a shareholder, what is the process of granting them ownership? What do you see, Marina, as the purported process? And I'll tell you what I think is the real process.
Okay, here's what I get.
Yes, no.
The daily practice is I am preparing a tax return with, you know, looking at last year's return, and it's 100%, and the return is done and into a client for final approval. And I get an email back to say, oh, I have another owner that came in the business last year. And I say, great, thanks for letting me know. And
the owner says, where's Mary's K1? Why didn't you give her one? Who's Mary?
And then we start digging, we start pulling details that say, okay, I need a name, I need social security number, I need a date when that person became the owner, and what else is there? Did that person contribute anything? Now, do we have to update basis schedule? So now we have a whole new tax return that looks completely different. And we finally muddle it together because, of course, now it's 2 days before the tax season, and we send it to IRS and we hope everything is fine. There's no legal document for Mary to be another S Corp shareholder, and we just hope to God that they listen to us and actually go back to the attorney and get the document done after the fact. But that's my experience with bringing in another shareholder.
So the napkin. Look, it says here on the napkin that she's a shareholder.
Mm-hmm.
Let alone if there's any kind of dispute about how much shares she purchased with her money, if she gave any money. So yeah, so we on my side of things, I get that call a lot from Marina's people to say, well, you know what, we talked about you know, Mary becoming an owner, and so Marina's just waiting for you to prove that she's the owner. So the real process, you have to think about your ownership of the company as really shares of stock, if you will. Just like you might have shares of Google, although it's not that fancy, it's the same concept. So if you're going to give some of your stock to someone else, unfortunately, you got to think about how you're going to do it. Am I, Joanne, going to sell you, Marina, my shares? Or is the company going to issue more shares? So if I have 100 shares, are you going to get 100 and now there's 200, or are you going to get 50 of my 100? That seems ministerial when it's two people, but depending on how you've set things up for tax and depending on how your operating agreement has been written, if there is one, this can make a big difference when it comes to how we calculate who's got the right to vote. Speaking of voting, so quite a good day to talk about that. So it's important that we know what we're doing. Are we selling additional stock of the company and diluting your ownership, or are you physically handing over your shares? Sometimes it's a 6 of one, half dozen of the other for tax purposes, but sometimes there's a big difference. So we need to be mindful of that first. Secondly, when we convey that, we have to do a bill of sale, do an assignment of membership interest or assignment of stock if it's a corporation, membership interest if it's an LLC. That assignment is physically how we evidence the handing over of that stock certificate. Oftentimes in closely held companies, there isn't a physical stock certificate like there used to be for the publicly traded companies where you would have something to hold in your hands. We can make them if people feel strongly about them, but it's not a necessary part of the transaction. But we have to indicate that that ownership interest has been transferred. We also will have some documentation to go along with that in terms of a hold harmless agreement that says, hey, you were the owner from today before, so if there are claims that come up either from employees or customers or vendors that really you are personally liable for them because you were the owner before today. If the company is liable, I don't want them coming after me because I wasn't an owner then. So, so those types of agreements are important. And you know, what else, how are we going to have to change any of the voting requirements? So sometimes people are adding someone and they don't have an operating agreement. Well, it's very important that now that you've got someone else to be in business with, how are the decisions going to be made? What's going to be majority rule? 51% approval to do it. What's going to be super majority, maybe 75%, and which decisions need to be unanimous consent? People pay substantially less attention to that when they're by themselves, despite my pleas. But now that there's another person to contend with, you know, what are they in charge of? What decision-making authority do they have? Do they have legal authority to bind the company, to sign contracts? Do we need to update the Sunbiz listing to show that person's ownership? There's a variety of reasons why you would want to do that, or maybe opt not to do that? Is this person coming in for operational purposes? Are they simply providing capital? So they're really an investor. Are they going to help you take the company to the next level? So all of those things need to be taken into consideration. If there's an existing operating agreement, the new partner is just going to sign a joinder to basically agree to that existing operating agreement. If there isn't one, then we might be creating a brand new operating agreement from scratch that both members will sign. There also needs to be a written consent to action where you, as the sole owner, founder, vote to approve the addition of a new member. And that's all. That corporate formality seems silly when it's just me, but remember my mantra: if you're saying it's just me, you're making Morgan & Morgan's argument for them. If you were selling and you were operating this like Google, there would definitely be approval of a vote to show that yes, all of the shareholders, even if it's just one, agree that yes, we do want to add or admit a new member. So I hope that answers your question. We have one more that says, if I were the sole owner and would like to hire 2 part-time employees, which entity would be best, S Corp or LLC?
We'll get to that in a minute. I did see that
Okay.
question,
Okay,
which
great.
actually, this is a great segue, because now what I really wanted to talk about, the pros and cons of either partnership or an S Corp, is what kind of business we have. And so let's say that we're running just a regular operating business. Either we are providing a service, we're selling goods, we are providing maybe consulting, we are maybe a realtor. So anything where you are providing, I guess, service or selling goods as an active business income. If it is that type of business, an S corporation is almost always going to be your number one choice. And I'll explain why. When you are operating an active business income, it is considered by IRS to be earned income. So if you were a sole proprietor and you were doing this on your own without having any entity or a corporate structure or anything like that, you would be considered self-employed. And as a self-employed individual, since you are not being employed by somebody else, you're being employed by yourself, you are performing the same type of work as you would be if you were an employee, which means that the income that you're earning is subject to not just income tax, but also self-employment taxes, which is Social Security and Medicare. People that work for an employer oftentimes forget that there's Social Security and Medicare tax, because the employer always withholds the employer's share and employees' share and remits everything to IRS without the employee ever even worrying about how much of those payroll taxes. It's sort of as a given. However, when you start your own business, you go on your own, you become self-employed, all of a sudden you start getting hit with those payroll taxes. And it is really on your what's called earned income. So earned income, for the purposes of ease of this discussion, is really your active business income. Now, when you are, again, self-employed, that you're paying that self-employment income on or self-employment income tax on both sides of your earnings, because now you're the employer and now you're the employee. And that is combined 15.3%, and that can add up really, really quick. In fact, you could be in a lower income tax bracket. You could be paying income tax at a rate of 10, 11, 12%, and your payroll tax would be the higher tax out of your total tax you have to pay. And that really gets folks' attention real quick, because all of a sudden they run this business, they make 100,000, they come with a tax return and say, oh my God, I can't believe only on 100,000 I had this much to pay. Sure, because it's a combination of income tax and self-employment taxes. So this is where an S corporation comes in. An S corporation is the only really corporate structure that is really where the income that's taxed to the shareholder is not subject to Social Security and Medicare tax. Because for that purpose, IRS is putting you as the owner of the stock kind of on the same footing as an owner of any of the other shares of any other corporation. So when you receive income from the S corporation, it's kind of like a benefit to you for being the owner. It is your reward in a way. Now, you are going to pay tax on your share of the S corporation income, but again, you're subject to income tax only, not payroll tax. IRS says, okay, this is excellent. We're giving you this ability to save on the self-employment taxes, but we still know somebody there is doing the work for this S corporation to generate this active business income or this earned income. So someone's got to get paid for doing the actual work. So if you are the shareholder who's actually also working in the business in whatever capacity, IRS requires the shareholder to take a reasonable salary from the business. On that salary, you're going to pay payroll tax, and that's going to be considered your earned income. But the rest of the net income that's getting passed to you from the S corporation is subject to income tax only. So this is where tremendous tax savings opportunities come from running an active business by being an S corporation. So essentially, you are getting paid via salary for the work that you're doing, and then the rest of the net income that you get is really your reward for being the owner in this business. And we actually have a separate webinar coming up in several weeks about what that salary should be. But really, the ability to take the salary and protect the rest of the net income from being subject to payroll tax is a huge, huge advantage of being an S corporation. So I think to answer the question that we just had, if you have a company that is really providing they're running a business, again, active business income, providing a service or selling the goods, and you've got some employees, then it would make sense, without knowing the particulars of your situation, that you are an S corporation and you're paying the salary to these employees, and the rest of the net income that comes to you is not subject to that payroll tax. So that's the key issue. With the partnership, even though you're still getting subject to income tax on the net income that's passed to you from the partnership, unfortunately, all of the income that comes from the partnership is still considered by IRS to be earned income subject to self-employment tax. Again, this is in the entity that's providing, that's earning active business income. We're going to get into a different type of entity in just a minute. So if you're thinking about your regular entity, let's say you're providing consulting, or you're a real estate group, or you're selling widgets. If it is an active business, if you're running it as a partnership, everything that is passed through as an income to you from the partnership is subject to self-employment tax. So the thing that is very similar there is that the income is taxed at the owner or the partner's level, subject to income tax, but the S Corp allows you to save that 15.3% tax on that net income, and that can be thousands and thousands and thousands of dollars. And as your business grows, the savings grow. So oftentimes the folks may start out as a partnership, again, back to our discussion 10 minutes ago, because it's easier, or because it's, that's what your operating agreement says, and the business may be small, maybe generating a loss, and then all of a sudden you start making money, and all of a sudden you start getting those K1s from the partnership return that shows that all of that income is also considered earned income and subject to that 15.3% self-employment tax. And it just gets, again, it gets everybody's attention real quick. And a lot of times that often becomes a trigger where we can go and make an S election to convert that entity into an S corporation and realize those savings. So oftentimes, again, we can make that election later in the entity's life, but that becomes a huge, huge deciding factor as to what type of income this entity is going to earn, and what are our tax savings going to be from it. So that is really applicable, again, when we're talking about active business income. Let's now turn our attention into anything that's holding real estate, as that becomes a huge discussion when we sit down with people who may be running a business, but they also want to own property. real estate income, such as rental income, or, you know, just income maybe from, and I don't want to say flipping property because there's flippers that do it for a living, but if you are an investor and you own property and then you sell it, that type of income is actually not considered active business income by IRS. And typically that income is not subject to self-employment tax. So having an S Corp in place there to realize any tax savings really doesn't work. And oftentimes people say, well, I have an entity. I heard I should be an S Corp. I heard there's a lot of tax savings. Let me form an S Corp to put my rental property in it. That an S Corp won't help you because you're already not going to be subject to self-employment tax, because rental income is not subject to self-employment tax. By definition, it is not an active business income. Mm-hmm. So you know, people make that decision because they hear or Google or read kind of different things, but where really then comes the education when clients come in our office and say, well, I'm thinking of buying a rental property, whether it's a residential rental or a commercial building, and what should I be? And that's where we really get into a partnership being the best structure in place for real estate ownership, because again, you don't really need the tax savings of an S corporation, but here are the bigger benefits of being a partnership for real estate holding purposes. So oftentimes you may have a residential rental that you buy and you're managing it, you've got rental income coming, and then you really like the property and you say, you know what, I think that I want to live in it. I want to make this my home. And you're going to say, well, can you know, me and my wife are partners in a partnership. We own this property. So can we take it out of the business and now live in it? And, you know, we own it through partnership. So why not? Well, if you own it through a partnership, yes, distributing that property to you is not going to trigger a taxable event. However, if you own that property in an S corporation and you want to take it out still for your own personal use, you actually have to sell it to yourself and generate capital gain. And people don't think about that, but we see that, I don't know, almost once a week. I feel like I have to have this discussion with individuals. So again, you've got our real property that you're potentially thinking of distributing. Maybe you want to for a different use. Maybe you want to, you know, start a different business and recontribute it there. If you've got real property stuck in an S corporation, the only way to get it out is to realize capital gain. Now, if the property is in a loss position, that's fine. But oftentimes, and when you really need to take this property out, it is going to be in a gain position because that's just the way it works. So you are kind of stuck with having that property in an S Corp until you really sell it to a third party, but you don't have any flexibility to change use or put that property into another business or anything like that. And that's the kind of it's, you know, sometimes if you see it called built-in gain, but it really is a huge deal when you've got real property inside an S Corp versus inside the partnership. Joanne, I'm sure you see that even a lot more than I do.
Not only do I see it a lot, but it really upsets me a lot because there's also a liability issue here. It's not just the tax problem, but if you have an operating company and you hold your real estate investment inside that same operating company, yes, for tax purposes, it's a disaster, but also if something happens, if somebody slips and falls in the property, if there's some liability on behalf of the company, now the property is an additional asset exposed for collection of those creditors. So from an asset protection standpoint, it's a different bag of problems, but it's just as problematic. It's and like you said, there's no. Sometimes I'm just like, well, you don't want to pay the built-in gains tax, so you're going to continue to march on knowing it's the problem, and that's worse when you know better, you do better. And it's one thing to have it set up like that when you don't know, but oftentimes, you know, the tax consequences just a lot for somebody to justify doing that transfer. And then not to mention, you know, the side effect of having the property in a separate LLC and then having sales tax on the rent. And that's a different webinar. We'll take complaints for that as soon as we open.
That's awesome. Yeah. And so kind of as a general rule of thumb, we always say that if you're going to have a rental property or any kind of investment property, please, if it's more than one person, we want this entity to be a partnership. The other benefit of doing that on tax, from tax standpoint, is that if your entity borrows money to buy this real estate investment, so you may personally not put anything in, but you form an entity, the entity borrows from the bank and buys a property with this loan, is having this debt inside the company gives you, the partner, the ability to take losses and actually realize those losses and use them on your tax return. So even though you personally didn't borrow and you personally may not be responsible for this debt, but if you're a partner in a partnership and the partnership borrows money and the partnership generates a loss, you are able to take advantage of that loss on the tax return. Inside the S corporation, things work a little bit different with the loan. If the S corporation borrows money, you personally did not put any money in. If an S corporation realizes a loss, you unfortunately cannot take that loss unless you put skin in the game. So even if you guarantee the loan, it still doesn't give you, in IRS's eyes, enough skin in the game where you're able to utilize, borrowing of by company as the ability to take the loss. So that's where I think on the partnership, it really, people do like to be able to, without having to put money in. Oftentimes it's a rental, there's going to be losses generated, especially in the first couple of years with all that depreciation expense, and you're able to get those pass-through losses and use them on your personal tax return. So that often is another big tax advantage in holding any real estate in a partnership versus an S corporation. And it may seem a little bit counterintuitive because they're both kind of a pass-through entity concept where you as the partner, the shareholder, get taxed on the pass-through your share of the income, but these little minute details really do make a big difference. Particularly this issue of the loans inside the S Corp has been in IRS courts for a really long time. And people have argued and said, I personally had to guarantee the loan that my company borrowed. And IRS still comes back and says, no, it still doesn't give you the ability to take the loss. You essentially have to borrow money yourself and put it inside the S corporation, and then you're really truly considered to kind of have enough skin in the game where now it's your personal money, and then if an S corp generates losses, you can take them. So that's the other big consideration. There's some other ones that again are beyond the scope of this, but I think the big takeaway here is when we're looking at the type of income, if you've got a real just operating entity with some active business income, S Corp is likely going to be the way to go. And if it's a real estate holding entity, the partnership is likely the way to go. And I always say likely because, the answer, the CPA will always tell you it depends. And, we're talking here about kind of the most common situations that we see. Your particular situation may be unique enough where we may start with one type of entity and do an election for it to be something different. You may change, certain circumstances may push you into one or the other, but generally speaking, I think this is a good guide for you to think about as you're starting to, get into these businesses and decide on the formation. But we really do encourage you to talk to a professional. An attorney and a CPA would be great because, sometimes people come to me and they say, well, this is it for tax. And again, I can make it happen for tax purposes, but if you don't have your legal documents to prove it, this will only get you as far as the tax return, but that's about it. Any other thoughts, Joanne, on that real estate piece being inside one entity or the other as far as the loans are concerned? Do you see any issues arising on, from people trying to borrow or guaranteeing stuff?
Yeah, the type of entity that you choose is also going to affect how the lending process and underwriting process is handled. So if you, again, can get your objectives out there in front of your professional before you form that company, we can guide you and say, okay, well, you know, banks don't like to see this. If you were planning on doing real estate investment and you're going to be getting loans to flip properties, for example, there's a way to a path of least resistance to make this as easy for underwriting as possible. Not to suggest you're doing something untoward, but setting it up in a manner that's easy for the bank to consume the information. And if we can do that in a way that still meets your objectives and is otherwise neutral to you, then why would you not choose that? So that's definitely something else to keep in mind, is that, you know, the pound of prevention. It's you get so much by having a clear vision of what you want this entity to become. And it's super easy for people to just say, you know, I'm just going to go to Sunbiz and jump on there and form it. Like that's the end. That's the beginning. Knowing what what button to push is what's important. Not, yes, everybody knows to go to Sunbiz, but what do you do once you get there, and what do you do after that? Because that's step 1 of 20, not 20 of 20. So.
And it's really important as your entity matures and grows and the purpose of that entity changes, to really keep that updated as well. Because like Joanne said, the S Corp and the partnership, it's not something you want to flip flop 1 year. If you've got an S Corp to begin with and you're running as an S Corporation and then something changes and you need to revoke that S election, it takes a little while to do it. Once the S Corp election is revoked, that's not something, again, you want to elect the following year. And, you know, for tax purposes, again, if you've got your assets inside, you've got real estate inside an S corporation, just by revoking the S Corp status doesn't get you out of the tax impact of being able to take that asset out without tax implication. And that's also an important thing, because, you know, everywhere once an S Corp, when it comes to that built-in gain tax of holding a real property, you are considered a corporation. Even if you kill that S election, you know, you may change ownership percentages or whatnot. That property was sitting in there when that entity was an S Corp, and if you want to take it out, you better pay capital gain tax. And so that's very important to see what your needs are and where this is going, and so on. So, and please let us know ahead of time what you're doing. Don't come to me at tax time and tell me that your entity, your consulting entity, also bought a building inside the LLC. Where we get this a lot is the client comes in and says, hey, I was buying a property when I went to the bank, and the bank said, well, you really, you know, the bank is giving advice, right? So the bank said, you really should have an LLC for legal protection, which is right. Again, that's a general statement. And the client says, I already have an LLC. Great. Let that LLC hold your bank. They don't know that that LLC is already used as your operating entity. And now they're not able to give you the advice that you need another LLC to hold your real estate. Now you're kind of stuck, and the issue becomes, and we see that all the time as well, is once you borrow money and the bank loans the money to one entity, if they come to us and we say, oh my God, you really got to separate, we got to remove this building from this entity, it's not so easy to do with the bank. Because even if you show the bank that you are still the owner of this other entity that's not going to hold real estate or vice versa, the bank, there's still a lot of issues for the bank to, you know, they essentially have to go through like a refi process, and it's just very, very cumbersome to change your borrowing, the borrower name and the entity structure. We've seen that happen several times, and it's just been nothing but a nightmare. So it's really important to get that ahead of time and think about that ahead of time, and you know, take advice from the bank or anybody else in the process, but until you speak to your lawyer or a CPA, to not, you know, pull the trigger before that.
Yeah. Boy, oh boy.
Yeah. So I think that's a lot.
If that doesn't scare you.
If that doesn't scare you.
Wow.
Yeah.
We have one last question about depreciation. If there's a benefit for depreciation in S Corp versus an LLC.
Nope.
Same.
The same.
Same.
Yep.
Perfect.
Mm-hmm.
Well, I think we've done all we can do to that.
I think so too.
Courtney, our lovely, lovely guru of all things digital, has put out our schedule for the balance of the year, so you can find all the topics that are upcoming. Next week, hold on to your seats, we're going to be talking about the difference between stock purchase agreements and asset purchase agreements. Jackie is just going to be in hog heaven. She's not going to know what to do first. It's quite possibly one of her favorites. So if you have questions in the meantime, you're welcome to reach out to us. As always, our recordings are available on your YouTube pages, on the Koontz Associates and Koontz Parkin websites, and also on our Facebook pages. Thanks so much for joining. We will see you next Tuesday.
Thank you.
Bye.